William. I am Tim Mahan from the English department. I am the acting director of the Medieval Institute. I just want to say a few words of welcome. As Megan says, this is the 19th time this has happened, this colloquium in conjunction with the Mellon Foundation, which arranges for an assistant professor and generally someone a little bit advanced as an assistant to come in and spend a year at the Institute, generally finalizing a book project, and then having this opportunity to have experts, in our case today, literally from around the world, to respond to what the person has been able to work on during the course of the year. This is last year's Mellon Colloquium. And of course, all was going well until about March, and then it wasn't. And the colloquium had to be postponed. So we're hosting last year's colloquium today. And last year's Mellon Fellow was Michael Heil of the University of Arkansas at Little Rock, who will be speaking on clerics, courts, and legal culture in early medieval Italy. We have 3 respondents that were arranged for by Michael in conjunction with the MI. They are Maria LaRocca from the University of Padua, specialist in medieval history, whose research works on medieval history with a particular focus on Italy. The next speaker will be Abigail Fury from the University of Kentucky, whose research focuses on the intersection of religion and law, and especially, I suppose, in canon law. That's when the break will occur after Abigail, and then we will come back with Warren Brown from Caltech, who works on social and political history of medieval Europe, especially the power of law and written culture. So a very wide range of expertise. And it's after that that we will have the question and answer session. In terms of moderating all of this, this will be done by Megan very ably. And I am, again, I'm very glad to be able to welcome people to this event. And I will turn the podium, as it were, over to Michael at this point.
Great, thank you. And I want to start with some thank yous. First to the Medieval Institute, for giving me the really unique opportunity to spend the year at Notre Dame last year. I think as Tim just described it, there is nothing else quite like the Mellon Fellowship in medieval studies, intended for a junior faculty member to work on a book. And time to devote solely to research and writing is a luxury in any circumstance, but to be able to do it at the Medieval Institute was a real privilege. The Institute and its library are kind of unlike any place I've worked before. And it really does offer the ideal environment for a medievalist, especially one working on revising a book project, with kind of virtually everything you need at your fingertips. It really is a special place, and it was a delight to be able to spend the year there last year, even though it was a weird year at the end for everybody. I'd also like to thank in particular the staff of the Institute, Megan Hall, Julia Snyder, Thompson Guster, Tom Berman, and now Tim Mahan, for welcoming me so warmly to the Institute, for all their support last year, and now for hosting the colloquium. I'd also like to thank the 3 other speakers who will be following me, all of whose work has had a deep influence on me and shaped this project. And I'm grateful that they've agreed to read my manuscript and participate in the colloquium today. And then finally, of course, thanks to everyone who's here. And I look forward to talking with all of you at the end of the colloquium. So in my comments today, I'll try to offer just a very brief overview of my book project. First, by saying something about the impetus behind it, and then outlining its main conclusions. The book at its core is about disputes, and in particular, the ways that clerics prosecuted disputes with each other in early medieval Italy, between the 7th and the 9th centuries, the Lombard and Carolingian periods. Disputes are, I think, intrinsically interesting, probably for everyone, but for historians especially, because they offer at least the promise of pulling back the curtain, of showing us how things really worked. This is, of course, especially alluring for legal historians. In court cases, we ideally get to see law and judicial institutions in action, as it were. So for a long time, I've been really interested in court cases and what they might reveal about law more generally. It was in a seminar in grad school with Robert Somerville, who just recently retired from Columbia, that I really became interested in ecclesiastical disputes in particular. In that seminar, we were looking at the church councils of the 11th and 12th century Reform period. And I became really fascinated with the ways that conflicts between ecclesiastics, between bishops or between bishops and the monasteries in their dioceses, for example, the way that those conflicts played out in church councils. This was also the period, as many of you know, when the papacy was coming to play an increasingly central role in judicial administration through the use of papal legates and increasingly at the papal court in Rome. And looking at all of this as an early medievalist, I began to wonder about the earlier period, the kinds of disputes that were heard in papal synods or by papal legates or at Rome in the 11th and 12th centuries. How would they have played out in an earlier period, say in the 8th and 9th centuries? So that's one context for my interest in what became this project, trying to answer the question of whether some kind of ecclesiastical justice existed in the early Middle Ages, and if so, what it looked like. The project also grew out of my interest in justice and law in early medieval Italy. There is an incredibly rich and deep tradition of scholarship on the practice of justice in early medieval Italy. This scholarship focuses overwhelmingly on the placeta, or public courts. Placeta were court hearings presided over by various representatives of public authority, such as counts, royal missi, legates of the king, and sometimes by the sovereigns themselves. And the placeta were often attended by a sizable number of inhabitants of the local area. Scholarship has focused on the placeta in particular for a few different reasons. First, there are a lot of surviving records of these cases. There are about 150 cases, case records surviving for the period down to the year 900, and then there's many more for the period after that. Also, for the period from the Carolingians in the late 8th century down to the year 1100, the records of these cases have been collected and edited as a distinct corpus, I Placitio Regnum Italia, by Cesare Manarese in the 1950s. And that's something that's not true for most other parts of Western Europe in this period. And this makes these records easily accessible and easily comparable to each other across time and space. Finally, the placeta, these public courts, really do seem to have been quite central to the administration of justice and to kind of public life more generally in the Kingdom of Italy. And they remained important much longer than those public courts in many other parts of Europe, down to around the year 1100, as Chris Wickham has emphasized. So because of all of this, that is because there's lots of these placeta cases surviving, because they've been collected as a corpus, and because the placeta really do seem to have been important, these documents and the cases they record have been the focus of this large and growing body of scholarship of very, very high quality. And a key landmark in that scholarship is Francois Bougard's Magisterial Survey of Public Justice, published in 1995. So this body of scholarship has taught us a lot about how justice worked, about forms of proof, about the use of writing in court, about the use of legal norms in court, and about judicial personnel, people who administered these courts. And I'll put in a plug for a recent article I wrote in History Compass that kind of surveys some of this literature. And this work, this body of scholarship, provides the essential foundation for the research that I do in the book. But as I discovered, the more that I dug into this topic, the placeta quite clearly did not show us the whole picture when it comes to justice in early medieval Italy. The surviving placeta concern a quite narrow range of cases. The overwhelming majority of them record disputes about land. And in part, that's because land was really important and was frequently fought over. But surely it also reflects something of a preservation bias, since records of land disputes retained their usefulness even long after the original disputants were, long gone. Most of the rest of the surviving placita, about 10% of them, concern personal status, the personal status of peasants, whether they were free or unfree. And these are cases that have been attracting more and more attention recently. Both of these classes of cases tell us a great deal, but they still concern a relatively narrow range of issues. Some of you may be familiar with Théodore of Orléans' poem, Verses Against Judges, which shows us, or at least suggests, a much wider range of business that might come before a 9th century judge. So because we mainly have land dispute cases with a sprinkling of personal status cases, that's what the scholarly literature mainly tells us about. And so I wondered how we might get beyond those confines. And I soon realized that focusing on ecclesiastical cases in which both parties were clerics or ecclesiastical institutions, was one way to broaden our perspective, to find forms of justice, judicial procedures, and varieties of legal argument that we don't see in the placita that have been the focus of most scholarship so far. So that's kind of all to explain what got me interested in the topic of the book and why I thought it was a fruitful topic to explore. Because I was not focusing on a class of evidence, placita records, but rather on certain kinds of legal disputes, those between ecclesiastics, I ended up considering a much wider range of sources than have usually been brought to bear on legal history. The evidence for ecclesiastical cases turns up in all kinds of places. Placita and other diplomatic sources are still important, but other genres of sources also offer crucial evidence, including legal compilations, letters, poetry, history writing, and hagiography. Taken together, these sources show us a much wider landscape of justice than studies based solely or mainly on the placita have shown us, as well as a wider range of kinds of cases. For instance, disputes over tithes, over the control of churches, over metropolitan jurisdiction, in addition to the familiar land disputes. The book proceeds on the basis of case studies of individual ecclesiastical disputes, attempting to work out each case's internal logic. Each case is different and presents its own problems of interpretation. Very rarely do we have evidence that shows us the entirety of an ecclesiastical dispute from its inception to its resolution. Instead, we usually have snapshots of moments in that process. So a great deal of the book is devoted to trying to piece together the particulars of individual cases, to figure out what the institutional trajectory of a case was, what stages of adjudication it went through, for example, and to reconstructing the arguments and the evidence that each side deployed to try to win its case. I'm not going to try to summarize all of that today, but when we take all of these cases together, for all their individuality and their peculiarities, I think two defining characteristics of ecclesiastical legal culture emerge that were widespread across the Kingdom of Italy and that were persistent across time. The first characteristic is the sheer multiplicity of judicial forums that clerics made recourse to in prosecuting disputes with each other. There was not a straightforward ecclesiastical channel of justice of the sort that would develop around the popes in the 11th and 12th centuries. There was no neat ecclesiastical analog to the secular placita. The judicial landscape that clerics inhabited was a very complex one that included the placita, but also church councils, episcopal tribunals, appeals to the Pope, and other more informal venues. An especially vivid illustration of this comes from a long-running dispute between the bishops of Arezzo and Siena in Tuscany over control of churches in the territory between their dioceses. Our first fragmentary evidence for this conflict appears in the mid-7th century, and it would continue on intermittently all the way down to the 13th century. But in just one 40-year period in the 8th century, between the 710s and the 750s, this conflict occasioned at least 7 different judicial events: a judgment by a royal legate, a royal confirmation of that judgment, an inquest by a different royal agent, a judgment by a synod of Tuscan bishops, a judgment by the king at the capital in Pavia, a papally mandated judgment by a panel of 3 Tuscan bishops, and then finally a papal confirmation of that episcopal judgment. Now, this is an extreme case, but this kind of movement between many different forums, including between forums we might consider secular and ecclesiastical, was actually very common. Exploring how and why ecclesiastical cases moved between different forums in this way is one of the main concerns of the book. One of the core insights of the body of scholarship on the settlement of disputes in early medieval Europe is a recognition of how important the web of relationships connecting individuals and groups was in determining how disputes played out. And clerics enjoyed an especially broad and dense web of formal and informal relationships. These included relationships with local elites and local communities whose identities were bound up with local ecclesiastical institutions, relationships with rulers who professed a duty to protect and defend churches and who often relied on clerics to perform various political or institutional functions, and with their superiors and peers in the ecclesiastical hierarchy, to whom, according to canon law, clerics should turn when internal conflicts arose. So all of these different relationships might shape how clerics responded to conflicts with one another, perhaps by facilitating informal settlements, but also by opening up various formal institutional pathways for seeking justice. In this environment, clerics' skill in discerning and navigating all of the available judicial pathways, or in creating new judicial pathways, could be crucial to their success in winning their case. And very frequently, the legality or the appropriateness of a potential legal forum itself became the object of argument between the parties. So this complexity of the judicial landscape and the necessity for clerical litigants to be able to chart the most advantageous course through this landscape, and often to argue about it, is the first core characteristic that the book reveals. The second core characteristic that emerges is clerics' skill and sophistication in crafting and delivering legal arguments that often hinged substantively on canon law, the law of the church. There has been increasing recognition of the sophistication of early medieval canon law, of the variety of purposes to which it was put, of the specific aims with which it was copied, reorganized, and sometimes forged. But relatively little scholarship has focused on how canon law was used in legal practice. Yet when we start to look carefully at the records of ecclesiastical disputes, we start to see canon law all over the place, being used in intelligent ways for immediate practical ends. Some of these uses of canon law are obvious and obviously impressive. For example, in the 880s, Bishop Leodin of Modena wrote a letter of complaint to the abbot of the monastery of Nonantola, whom Leodin thought was infringing on his episcopal prerogatives. It's long been recognized that Leodin's letter is kind of chock full of quotations from the Pseudo-Isidorian decretals, which had been forged in Francia a few decades earlier, as well as a few late antique conciliar canons. What hasn't been fully appreciated before, and what emerges only when we read Leiden's letter closely and in conjunction with the other evidence from Modena and Nonantola, is how carefully and cleverly Leiden deployed this canonical material, shaping it to form real arguments, and arguments that made perfect sense in the broader context of his dispute with the abbot. But virtuosic displays of canonical expertise, like we see in Leiden's letter, were not the only way that one could use canon law. Easier to miss, but potentially just as effective, was the use of a single, well-chosen canon, artfully deployed in conjunction with documentary and other evidence as part of a courtroom argument. Some of these arguments only become clear when we read the evidence very closely, trying to really make sense of and take seriously what clerics supposedly said in court. When we do that, we sometimes find that a seemingly empty reference to the canons, secundum canones, for example, actually points towards a substantive canonical norm that structures an entire line of argument. An added complication here is that canon law in this period did not exist as a single coherent and consistent corpus of law. There was nothing like the Decretum of Gratian, the text that would become almost the standard book of canon law in the 12th century. Early medieval canon law existed in a dizzying array of collections, families of related collections, and individual sui generis manuscripts. The sum of canon law as it was known could vary radically from region to region and from one ecclesiastical center to another. And to understand how clerics made canonical arguments, we need to be sensitive to that fact. We need to think in terms of the specific canonical resources that were or may have been available in particular times and places. This is not always easy because there are still large blank spaces on our map of the canonical terrain, particularly in Italy. But this work is worth pursuing because it yields some surprises. In some cases, for instance, what previously seemed like a rather vague reference to some general canonical idea turns out to in fact be precise quotations from locally available canonical resources. Canonical arguments certainly can't be found in every case, but the evidence for them is, I think, substantial enough and chronologically and geographically diffuse enough to suggest that practical canonical literacy and a basic argumentative competence were widely shared features of clerical legal culture in early medieval Italy. So I hope that that gives some sense of the scope of the book project and what it aims to accomplish. My hope is that it might help to broaden scholarly conversation by encouraging others to look for and look at other forms of justice beyond those that have been the focus of scholarship, and among specialists in canon law in particular, to explore the somewhat neglected aspect of canon law in this period, its use for immediate practical ends, which I think has something to contribute to our understanding of canon law and law in general in this period. Okay, so that's all for me. And I'll turn things over now to Cristina LaRocca.
Evening, everybody. I say evening because here in Italy it's 5:30, so it's quite mid-afternoon. And I will present you a paper that me and a younger colleague that Michael, I am sure, knows already, Gianmarco De Angelis of the University of Padua, like me, have prepared for our project that was just financed. And our project is about Lothar the First in Italy and the practices of the empire Lothar is showing, and also the surrounding institution. One of the most important was, of course, the monastery of St. Ambrose in Milan. Just a minute. Doesn't work. I will carry on like this. In the Italian documentary panorama of the early Middle Ages, the sequence of ordinary writings and the maddening monotony, as Paolo Cammarosano used to say, is sporadically interrupted by texts of a different nature. The Brevia, in particular, that heterogeneous ensemble of documents relating to the current management of land assets already attested in late antiquity as lists of people, lands, other moniminas, and variously declined later, but still considered in historiography as light because not foundational of property and possession rights. It would be enough to take a not too quick look at the table set up years ago by François Bougat on the types and chronologies of early medieval Italian documentary stocks to detect an essential fact: the emergence of Brevia alongside the usual acts of sale, donation, exchange assumes significant percentage figure in some places rather than in others, and according to chronological concentration that do not seem to be the result of the usual whims of the archival tradition. In Milan, among the cities of the Regnum, and in particularly during the Carolingian age, there is an undoubted primacy from this point of view. In the 9th century, of the 113 preserved documents, almost all, as we know, coming from the ancient archive of St. Ambrose, as many as 28, about 1/4 of the total, belong to the Brevia. Instead, in other parts of Lombardy, as you can see here, the archives of Bergamo, Brescia, Lodi, the only cities that have left us notarial deeds for the 9th century, did not reserve any breve, and the situation is identical in the major centers of subalpine Piedmont, Asti, Novara, Tortona, Vercelli. Moving toward the east, in Veneto, on 60 charters, we count 4 brevia, all from Verona, and not too different, even if much more massive absolute numbers, 271 pieces in total, is the percentage of surviving brevia in Piacenza. The comparison could continue by examining the Tuscan area, where the structure of the documentation is notoriously different, and the percentage number do not seem to overshadow significant quality data. About 10 brevia on 732 charters in Lucca, only 3 on 105 of the Amiata charters, and none from Pisa, Volterra, Pistoia, Arezzo, Siena, Florence. But it's better to stop here. These quick excursus clearly show that in Milan, in the Carolingian age, scripture in name and in breve form were used much more frequently than elsewhere. It is important to stress that this was not the case in the 10th century. 6 brevia out of 209 charters, and even less in the first half of the 11th century, where there are only 3 brevia out of 353 charters. Trying to account for this peculiarity is not the first objective of my intervention, but any reasoning that we will expose must necessarily deal with a documentary story that appears historically determined, with precisely marked time limits and elements of the diplomatic discourse, with no antecedent and with very few possibility of comparison later. Brevia, like those that constitute our basis of investigation, are in all 14 in Milan, had never been written before 844 and will not be written after 879, with some similarity of forms can be found in rare emergency from Piacenza and Verona in the late 9th century and early 10th century. What kind of story was entrusted to this text and how were they constructed? What was their functionality? What were the communication strategy? What kind of information, above all, do they give us about the communities that we see acting in them and determining essentially the same raison d'etre? And finally, what kind of legal culture of the clergy in Milan they undermine? Let's proceed in order. The narrative of the Brevia is very concise and has as protagonist the priest or abbots of the monastery, accompanied by a notary. And it is catch in a moment of mobility towards the possession of the monastery of St. Ambrose, located far from Milan here, in Brianza above all, but also in the Alto Lario near Lake Como and southwards in the liminal area with the Diocese of Pavia. In each place, there is a group of representatives of the local community to welcome them, accompanied by other men from more or less nearby location. The journey of the abbot of St. Ambrose therefore constitutes an opportunity for the member of the community to meet together and to meet on the same occasion members of more or less distant communities who have patrimonial interest or ties of kinship with the former. Each trip has its destination, a different location. I will try again to a different location where St. Ambrose has acquired for sale or donation new lands, both in the very recent past and in earlier dates. As for the structure of the Brevia, it must be said that beyond minimal lexical variation, it is also quite simple and substantially fixed. An initial phrasing with which the document defines itself, notizia breve, breve firmitatis, brevem securitatis et firmitatis, and it immediately declares its purpose, which is to preserve for the future, pro futuri temporibus, the memory, stability, and certainty of the memory of certain facts, in turn introduced by a generally standardized form and inserted in a narrative, theatrical, and performative frames. The public who assists on site is presented mostly with summary formulas, qualiter vel in quorum praesentia, which, however, over time become more analytical and specify dignity and function of the bystanders, praesentia bonorum hominum confirmatores. The curtains opens directly on the protagonist of the event, that is the abbot of St. Ambrose, and in one case, the Archbishop of Milan himself, is captured on his dynamic of approximation to the scene. The verbs are precisely those of movement, venet, veniens, and portrayed with his retinue of men of various kind. The notary, first of all, who is not infrequently also the author of the previous charter, who had ordered the donation or sale of the goods to the same monastery, and then a group of homines residing in the same locality. In front of them, after showing and having publicly read the written document proving the ownership of monastic right, the representative of St. Ambrose animates an elaborate ceremony, marked first of all by deambulationes on the land he declared to be his property, and their material vestitura, which he accomplishes by lifting clothes, touching the wines and the grapes of the land belonging to him, the fences, the supporting poles and the door of the houses. It is a real ritual of appropriation, which, through physical contact with the structure and the land and crops of the village, flaunts the material signs of public knowledge, affirm the property rights of the places that the monastery has acquired per legem. The link between touch and ownership has been extensively analyzed in social sciences, where psychology and marketing researcher has pointed out interesting aspects. Touching an object not only develops in the person who acts the sense of perceived possession, a concept very different from real possession, but significantly gives an emotional value to the object itself and increases its value. In our perspective, this aspect is particularly stimulating since, as can be seen from the short list of the features touched, it is in fact a selection of features aimed at pointing out and enhancing the salient, the important part of the acquired properties, the supporting pole of the house, its roof, the vineyards, the boundaries of the plot, creating and underlining at the same time a space of shared value that hierarchizes the space itself and point out the authority of the missus of St. Ambrose to mark its important parts. It is obvious that by witnessing to this performance, the community is able to recognize both as most relevant elements, the one that are in fact touched, and it is able to understand them in their meaning not only of legal ownership, but also of perceived ownership and as parts for the whole. It is interesting to underline that in these documents, none of the sign of space sacralization underlined years ago by Barbara Rosenbein for Cluny for the subsequent period appear. The acquired space doesn't seem to have acquired following the deambulatio any characteristic of sacredness, but only of full possession through the emphasis of its relevant parts. Similarly, the brevia do not mention an explicit correlation between the date chosen for the visit and a particular religious celebration, even if June the 10th, the day of the first deambulatio in the Vicus of Gudi, is the birth of the Milanese Bishop Barnaba, and August 17, the date chosen for the second ambulatio in Mendrisio, is the day that commemorates the birth of San Simplicianus, Bishop of Milan, and the octave of the birth of St. Lawrence. However, it seems possible that in order to better impress the content and tenor of the visit itself in the mind of the bystander, the monastery had chosen an already significant date to which the ambulatio could be associated. In the collective memory, as is known in practice and in the Carolingian conception of time, time on earth appeared to be marked by symbolic time of heaven that organize and clarify its full meaning. There are precisely these absences, this failed underlining, that suggests that the procedure adopted by St. Ambrose has nothing new in itself, and that it was customary for the Milanese monastery to send its own official representative to ambulate in the rest of a village following a donation or sale of land in that place. The real novelty is represented by the written appendix of the ambulatory, namely the drafting of the brief itself, an innovation, as we said, with precise chronological boundaries on which I will have to return. However, let's concentrate on the context of the performative procedure. The meaning of these ritual gestures is clear, and it is equally clear to us the difference with respect to other brevia, notizie of vestitura, in which the subject of the action is the one who has transferred the ownership to St. Ambrose. In the cases under consideration here, instead, the author is not in fact present on the scene. In two cases, those relating to taking possession of the thing donated by Gunzo, deacon, and Judge Overulf, we know that they are even dead men, and at most he speaks through the cartula he had issued at the time. In our example, the document that ensured the ownership of the right somehow ignites a procedure which is both visual and auditory. The charter is brought to the scene of the ritual, shown, read in detail, and on the basis of its tenor, the deambulatio is given life, fundus for fundus, and then field by field, and to the writing, sometimes, of the name of the Massari and Laboratores who reside there. The munimen or munimina represented, therefore, the necessary level, the fundamental prerequisite of any claim, and it could happen that with greater caution and in potentially more controversial situation, very conspicuous dossiers of written documentation were produced in public, not limited to the founding evidence of the possession, but to all the charter capable instead of recalling an entire documentary history to make it unassailable. And yet, two considerations are necessary. First of all, it was not those muniminas that prompted over time a careful conservation by the monks of St. Ambrose. To give an example of the various carte that concern the controversial case of the Curtis of Limonta, the Milanese monastery kept only the diploma from 835 with which Lothar I donated the Curtis of Limonta to the Milanese monastery. None of the other charters was preserved, that is, that the monks did not bother to keep them in the dossier. This evidently shows that the selection was made in favor of light text, such as our Brevia, which the monastery instead carefully preserved. Secondly, and in direct connection with the observation just I made it seems to us that the cases under examination testified that precisely those regulators of property and possession required a surplus of information that public reading evidently could guarantee. In the present, in the presence with the help of the community directly interested in the change of the asset and the internal balances of locus. Now, the competition, but also take the form of an implicit acceptance of the new order of things simply as an abstention from any dispute. Alongside the men of the community covered by the Breve, we see the convergence of other men who come from other locations, sometimes even very distant, who presumably were summoned by the Abbot of St. Ambrose as a consenting public. It should be noted that in the lakeside here, location farthest from the city, where evidently the monastery had not yet built a solid network of relationship and assets, the witnesses involved come mostly from distant location, as in the case of the Breve in Cannobio, on Lake Maggiore, and here the case in Ucto, where the local witnesses are joined by others coming from very long distances, Castelseprio, Bascapè, Segrate. What was the expected result from such involvement of the communities and the importance recognized to the Brevia of those public rituals seems very well demonstrated by one of the many moments that marked the controversy between the monastery of St. Ambrose and of Reichenau concerning the Curtis of Limonta. On May 17, 1880, by order of Charles the Fat, a placitus was installed in the Cathedral of Como to establish through an inquisitio of the inhabitant which monastery had jurisdiction over 6 monks of the Curtis. Well, the 8 witnesses who paraded one after the other in front of the court and who confirmed under oath the right of St. Ambrose on the basis of the mentioned diploma of Lothar I, that was dating back to 45 years earlier, were the same who in November 879 had attended the public reading of that imperial praesectum and then signed the brief, the Breve, in which the vestiture of the Abbot of St. Ambrose of the 6 monks was recalled per columnam de casa et confine Osti. In this example, obviously, the physical presence of members of the local community in the various public stages of certification transformed the representative of the community into active actors, favorable to the right of the monastery. With this, we have come to better focus on the role and methods of intervention of local communities in an asseverative process of the law that is directed by the institutional representative of the body and certainly owes its initial inspiration to an initiative of the holder of assets, but which nevertheless lives in a dimension of mutual recognition with the group of free men interested in any modification of the ownership structure of their respective places of residence. Hence, of course, the care, far from common in the St. Ambrosian and more generally Lombard maps of the 9th century, in accompanying the nominal identification of the witnesses of the Brevia with toponyms instead of only the link of affiliation. Here, hence, the careful selection of the presencery necessary to act as confirmatores among what we must imagine to be the village elite. Hence, also, the search for the greatest possible contribution of these presences in the evidently more controversial cases and in need of warranties. This last aspect seems to us very well illuminated by a Breve Form 856, which, for its unusual articulation of the dictation and the description of the res, combines a very thick eschaton where the intervention of 18 witnesses finds space instead of the usual 7 or 8. Details and peculiarities that are most likely due to the peculiar circumstances of action and documentation. It was the second time, it is immediately said, that the deambulatio was necessary, carried out in both cases by Abbot Pietro himself on the lands that Gunzo, already archdeacon of the Milanese church, had donated years earlier to the monastery of St. Ambrose in a place called Gignano, a vicus on the Rambro River in the ecclesiastical territory of Pavia. In addition, the monument issued at the time by Gunzo, which the monastery did not preserve, the abbot ostendi ibi atque relegi fecit, the previous breve illo introicionis et vestiture, not preserved today, but this time it seems it was decided to proceed with greater care, with a punctual inspection of all the microtoponyms and listing precisely the name of all the massari and laboratores. For example, in Gignano, Petrus proceeded first of all to all the house and court quas laboras Theodorisius, to carry on to that quas exinde laborat Petronace, to that quas exinde laborat Rotecauso. That is the property of the deacon Gunzo at the time gifted to the monastery. Then Pietro ambolavit in various localities cultivated in that place, supra camporas in ipso vico, each designated with his own microtoponym. In Albaro, in Runcore, in Acquamaria. The very description of Pietro's ambulazio includes much better detailed public ways of affirming the property, from the vestitura per furca de Cassina to a new ploughing of the field, ibi arare fecit, to physical contacts of the individual houses, which he discoversit et copersit, according to a modality that we will later find also in the Piacenza Brevia. As Ros Balzaretti clearly showed by analyzing the events of the property in Gignano, Gunzo donation transferred to the Milanese monastery a group of lands that had come to him through a process of progressive acquisition by a group of new settlers in the strategically and politically most interesting territory of the Italian Northwest, that is to say, the one that connected the capital of the kingdom, Pavia, and Milan, the most important urban center of northern Italy. Located about halfway between the two cities, here in Vico Noniano, Gignano allowed to follow with equal attention both the events in the Pavia court and the economic and religious ones of the metropolis, and therefore to gravitate in both spaces. The locality is in fact documented from the end of the 8th century, attesting on the one hand the frequentation of the place by an elite specialized in the control, distribution, and perhaps even production of precious metal objects, aurifices negotiatores, which proved to be very cohesive and linked together through the ostentation of mutual appellation or mutual affection. They are called each other dulcissimus amicus meus, dilectissimus mi semper. However, the community seems to be crumbling, and with it, all the ties created in its time since the first 30 years of the 9th century, when the monastery of Sant'Ambrogio cautiously begins, through the work of Deacon Gunzo, to acquire land in that place. The local network, thanks to this presence, changes completely within a few years, first to the compacting of assets in Gignano by the Frankman Unger, to flow a few years later into the hands of the Milanese monastery. As Balzaretti noticed, among the weaknesses of the aforementioned acts, there is no individual living or born in Gignano. There was certainly to be reiterated in an energetic manner and protected from any future dispute an ownership of possession, which in effect the brief tell us treated by the claim of a certain Bavone, Bavo, de ipso vico, which contested the ownership of St. Ambrose of a number of fields in Noniano. At first glance, his protest, which does not seem to have been supported by any written charter, was apparently doomed by failure, but the notary was obliged to record it in the breve, and this does not seem irrelevant. As instrument of legitimation of monastic right, the public rituals desired and managed by St. Ambrose were also precious occasion for individuals and rural communities to make claims and to organize form of resistance, to recognize and to be recognized. I still have one page. Can I carry on, Mike? Yeah. Whether Bavone was a significant exception on a recurring case series, we are not able to state. The texts, with the conciseness of their form, do not allow for further consideration. We could only limit ourselves to considering as probable the hypothesis that, as the base of trips, not without some expenses, there was the need to address objection and tension locally, perhaps only by preventing them. To ensure control of more or less distant possession, I will show you a small slide with all the distances that every notary is making in these 14 trips. To ensure control of more or less distant possession, and in any case in borderland, subject to friction of the most diverse nature, it is reasonable, in other words, to think that St. Ambrose had developed an effective strategy for ascertaining and advertising the possession, and that at a certain chronological moment he had commissioned his trusted notaries to develop a shared model for recalling events. I hope that this will work. I think not. It is animated slides, but as it doesn't seem to work at all, I don't manage to. That was a timeline slide, but there is no way I'm sorry. It is perhaps not coincidence that this need made itself felt in the 40s of the 9th century, and in particular in the period that followed the Treaty of Verdun, when threats of plundering of ecclesiastical assets filtered through the Placita and Narrationes of Luther's diploma, and at the same time the concession to the churches of the Inquisitio right to recover lost goods and right are thickened. Certainly, it's not coincidence that the practice of vestitura ended according to the shape and functionality described in the 1980s of in the years 80 of the same century. The promulgation by Charles III in 1882 of the Imperialis Institutio, which, together with a shortly later Capitular of Guido, will provide stringent rules for verifying the legality of the titles of possession and the definitive standardization of the Notizie di Placito through the figure of the Ostensio Carte, dates back to the same decade. A procedural model, the Ostensio Carte, that undoubtedly owes a great deal to the decade of experimentation conducted on documentation and its public use by Milanese judges, notaries, and abbots. These two, after all, a community, then other communities that in the Sant'Ambrosian Brevia of the full and late Carolingian age allows us to focus. Thank you.
I want to thank Michael for inviting me to participate in this. It's a real honor to be included in this group. And thanks also to Megan and the other organizers for putting this together. I was glad to read Michael's manuscript, not only because it was a pleasure to read and because I've profited from it. It hits right at a central problem that I'm facing in my own work. And this colloquium has given me an opportunity to think about that problem some more and to say what I think about it and invite you all to weigh in. Central to Michael's work is the following question: whether two central categories of analysis in medieval studies, lay and clerical, or secular and ecclesiastic, are useful for understanding how different people behaved in early medieval Europe. Michael's arena is judicial, and his answer to this question appears to be positive. In early medieval northern Italy, in the judicial arena, he does think it's possible to separate clerical from lay spheres of activity. He argues that clergy and monks in northern Italy before the 11th century had many interests in common with the laity, but they also had their own. They defended or advanced their interests with the help of the same judicial institutions and laws that the laity did, but they also had their own. Michael uncovers not only the sheer variety of legal options available to clerics with problems or grievances, but he also uncovers the intelligence, the awareness, the opportunism with which they used the options available to them. And among these options were synods, dedicated ecclesiastical courts, and canon law. There is a problem with all this, however. Michael keeps running into lay people. His clerics spend an awful lot of time in secular courts, appealing to secular judicial officials, pulling out Roman or other secular laws when it suits them. Lay and clerical, in fact, appear in his world to be profoundly intertwined, to the point that it can be difficult to untangle them. This phenomenon is reflected in the fact that Michael has had to create a special label for some of his documents. Next to lay documents, meaning involving only lay people, and clerical documents, meaning involving only clergy, he's forced to call many of his texts lay/clerical or quasi-clerical, meaning that lay people and clergy are involved in a given dispute side by side. In the world Michael describes, clergy and laity, the things they fought over and the way they fought over them and the tools they fought with are thoroughly enmeshed. Michael not only admits as much, the observation that they were is one of his major conclusions. And yet, he insists that the distinction between secular and ecclesiastical interests, secular and ecclesiastical judicial institutions and legal resources, is one that is fruitful and therefore worth making. Someone with a critical turn of mind might argue that he's imposing an artificial distinction on a world that did not separate the two spheres as much as we would like them to, at least before the reforms of the later 11th century. The crucial issues, one might argue, are not whether someone wears a secular or ecclesiastical hat, but rather power, influence, self-interest. As Michael makes clear, actors, both ecclesiastical and lay in his world, promiscuously resorted to the legal resources available to them in a way that would help them the most. Perhaps a more helpful question then might be not whether ecclesiastical cases went to ecclesiastical courts, but rather which resources, whether they were Lombard, Carolingian, papal, episcopal, whether they came from a capitulary collection or an anthology of canon law, were more useful to a given person at a given time in a given conflict. These questions notwithstanding, or better perhaps because of these questions, I'm glad Michael has written his book and invited me to comment, because it gives me an opportunity to confront a similar problem I am facing and explain to you and to myself why what I am doing, and by extension what Michael is doing, is a good or at least a defensible idea. In my current work, I'm staring at the same potential critique in reverse. I'm finishing up a book focused on the lives of the laity in Carolingian Europe. That is, on the activities, interests, and concerns of lay men and women when they were not interacting with churches and monasteries. This is a tricky problem because this alleged sphere of independent lay activity is very tough to get at. Almost all of the information we have about lay people north of the Alps in this period comes from ecclesiastical and monastic libraries and archives. We therefore see lay people, for the most part, unless they were members of the very highest elites, only when they were interacting with churches and monasteries, particularly when they were giving, selling, or exchanging property with clerics or monks, bishops or abbots, or their institutions, or getting into property disputes with them. The rare exceptions consist of a bare handful of documents describing property transactions among lay people that came to a church or monastery when it acquired the property concerned. It's natural then that when people write in general terms about Carolingian society, their picture of the laity tends to be thoroughly intertwined with their picture of the clergy, so much so that it's tough to distinguish them. And it's this pattern of source survival that produced the long-standing image that writing and record keeping in the early Middle Ages were primarily the preserve of churches and monasteries. According to this image, it was only in the 12th century that lay people started using documents on a large scale, as the needs of an expanding economy and government created needs for information and transmission and information storage that went beyond speech and human memory. This particular picture has crumbled over the last decade or so, in part because of a project I had the good fortune to be involved in that took all of the surviving traces of independent lay documentary activity and put them together. And we ended up arguing for a pervasive documentary culture in the early Middle Ages that both clergy and laity participated in at all social and political levels. But even this project concluded that it makes no sense to distinguish secular from ecclesiastical culture in terms of document use. And Michael notes this, by the way, when he cites us early in his manuscript. Nevertheless, the evidence that lay people did use documents to carry out legal things amongst themselves, no matter how thin, made me want to find out more about what those things were. And it has been the sources that I worked with in the course of the Lay Documents Project in particular that have lured me on with almost siren-like insistence. And these are the Merovingian and Carolingian formula collections. Now let me define these. These are collections of model documents and letters with most or all specific information removed so that they could be used as templates or sources of language when drafting documents. They survive in around 40 manuscripts from across the Frankish world from the 8th through the 10th centuries. And it's one of the interesting puzzles about them, by the way, trying to figure out why there aren't any for Italy, but that's a different question. A key feature of these formula collections is that they preserve models for a great many kinds of documents that have not otherwise survived. Moreover, many of the model documents that they contain have nothing whatsoever to do with the clergy. They deal with lay people only, although I do have plenty of what Michael would call quasi-clerical documents. But the formula collections are difficult sources. They contain a mixture of new and old texts. Some of them are even late Roman. This character of the formula collections raises the possibility that they are antiquarian rather than models for things that were actually used. Much of my work over the last decade or so, therefore, has been doing the detective work in the manuscripts required to show that the people who copied the formulas understood what they were copying, that they deliberately selected, updated, and corrected what they wrote, and then actually used them to help them draft documents and teach their students. From there, my next step has been to take the lay formulas and write an anthropology of the laity in the period when the manuscripts themselves are actually copied down. And this is the Carolingian period. This means exploring the things that lay people did, things they were concerned about, things they thought about, their ethics, even some of their emotions, when they were not interacting with churches and monasteries. There's a problem with this, however. I keep running into clerics and monks. First of all, it was clerics and monks who compiled, kept, and used the formula collections to begin with. Second, although I have many document texts that involve lay people only, many more of them present me with a liminal world where what lay people are doing nevertheless involves the clergy. For example, two lay people exchange property, but all of the property lies within the jurisdiction of a monastery. A lay dispute is handled at a court that is overseen by both a count and a bishop. A hot-headed youth kidnaps a girl and marries her without her parents' permission. Among the group of local worthies that intervene to prevent bloodshed and work out a settlement is a priest. Someone abandons an infant child who is then sold to someone who will raise him or her as their unfree servant. But it was at the door of a monastery that the baby was abandoned, and it was discovered by the paupers on the monastery's poor rolls. To add insult to injury, a lot of my lay transactions look just like clerical ones. The titles of the actors are just different. As a result, a great deal of what I say about the laity are things we knew already from looking at ecclesiastical documents. My chapter on personal relationships provides an example of this problem at its worst. And this is where I use formulas for letters, in which people ask for favors or respond to requests for favors to show how much Carolingian society depended on ties of patronage and clientage, sworn fidelity, kinship, and friendship to function. You got things done. You got help when you needed it by asking people in a position to help you, or who knew someone in a position to help you, and promising to do favors for them in return. The evidence from the formulas has forced me to say in this chapter that clerical and lay are so intermixed in the flow of power through these relationships that it makes no sense at all to separate them. One of my favorite examples is a letter formula in which a bishop from Passau in Bavaria writes to a count. One of the bishop's men had complained to him that some of the count's men had stolen his cows. The bishop asked the count to look into the matter, just as he was helping out one of the count's men who had fled to him to seek sanctuary because he had killed another of the count's men. And he asked the count to let the killer pay the victim's blood price and be received back into his favor. The titles bishop and count make no difference whatsoever here. All we are seeing is two powerful men simply acting as two powerful men. So, I live in fear of the critique that I am not saying anything new or interesting, that secular and ecclesiastical in the Frankish world were so intertwined that by focusing on the laity, by trying to pretend that I can write exclusively about the laity, I'm creating something artificial. Is this critique valid? Is there any value in writing about the laity in isolation from the clergy? And by value, I mean, do we learn anything? Am I pretending to do something novel when in fact I'm just repeating or rehashing things we already know perfectly well? And I'm not joking when I say I lose sleep over this. What I'm going to do now is lay out my defense, say what I think I'm doing that's valuable and why it's valuable, And by sort of reverse extension, why I think what Michael is doing is important and valuable as well. In the world of my formulas, we see that the lives of the clergy and the laity are intertwined, yet they are not the same. The documents go out of their way to distinguish between them. They even use the labels clericus and laicus. The collections, moreover, go out of their way to provide options for lay and clerical actors. You'll have a formula for a gift or sale of property to a church, followed by a nearly identical formula for a gift or sale between laymen, but they present the option. Sometimes you'll find a single formula offering language for both options. Even at this minimal level, this is useful information. The society we are looking at itself regarded the distinction between clergy and lay as important. Next, I would argue that sometimes it is important to establish that lay people did do things in the same way as the clergy. It's very important, for example, for understanding lay society to realize that lay people use documents in the same way for similar things as the clergy. In other words, document use, the technology of record keeping were not a clerical monopoly. Next, yes, the clergy and the laity do a lot of the same things in the same way, but there are some things that lay people do that are unique to them. For example, lay people have concerns about inheritance that clergy don't have. You see husbands and wives working out what to do with their property for the case that one of them predeceases the other. You see men writing documents to bypass the law and let their daughters inherit their property along with their sons. Laymen in the formulas get married and give their brides gifts of property before their wedding day. Laymen also steal their brides or elope with them. But it's not just men who are active. The amount of evidence in the formulas for women exercising legal agency goes beyond what we can see in church charters when women make property gifts to a church. In the formulas, for example, we see women initiating their own divorces. We also have two precious formulas dealing with violence by women. One of these involves an accusation of homicide by poisoning, or the formula gives us the option by sorcery. But the other one is really cool. A woman kneecapped a man's wife and kidnapped their daughter. Lay people, both male and female, loaned each other money and gave written receipts when the loans were repaid. One might give another power of attorney to handle some specific dispute or all of his or her legal affairs. Lay people sometimes dealt with old age in their own way. We find that old men and women who lacked a family to take care of them did not just give their property to a monastery and move in, as the ecclesiastical charters tell us. In the formulas, we find them adopting other lay people as their legal children in exchange for support. We also see free people selling themselves into servitude. Sometimes this is to pay compensation for something they had done or to pay a debt they could not repay. But sometimes they put their freedom up essentially as collateral for loans. That is, they agreed to become someone's unfree servant in exchange for money, but for a specified period of time, after which the loan would be paid off. In short, the formulas let us see some real and sometimes messy human situations that are not always visible in the ecclesiastical or monastic charters. Another point I might make: everybody used the resources available to them to get done what they needed to, but lay people had some resources that the clergy didn't, and vice versa. A layman, for example, could improve his position in society by marrying a well-connected woman. This included the unfree men we see frequently in the formulas who married free women, prompting their lords to issue documents saying that the couple's children would remain free. And of course, this works in the other direction too. Remember the Passau case about the cows and the homicide that I just mentioned. One thing that the bishop had that nobody else did and that affected the role he played in local society was his control over a church that could provide sanctuary. Similarly, in the world of personal relationships, clerics sometimes used clerical channels to do specifically clericy kinds of things. And the same goes for the laity. It's safe to say that letters written by one bishop to another asking him to allow his nephew to take up a post in his diocese, or by one abbot to another asking about a runaway monk, are strictly ecclesiastical. It's also safe to say that a letter from a count to his viscount, enjoining him to do justice without favoritism or taking bribes, is lay. But I'm on riskier ground with a letter written by Louis the Pious's courtier Einhard, which survives in a collection of Einhard's letters that got turned into formulas. In the letter, a man begged Einhard to intercede with his lord to let him skip an upcoming military muster, because the count who was commanding the muster was his sworn enemy and had threatened to kill him if he saw him. I would argue that this qualifies as a lay affair, and I'm using this example in my book, even though Einhard at that point was lay abbot of the monastery of Seligenstadt, and the man's lord was Abbot Rabanus Maurus of Fulda. But I am prepared to be argued with. I end up thinking about the problem this way. In the center of our picture, we have one big mass of interactions, behaviors, concerns, institutions, and resources that clergy and laity shared in common. Here, the labels secular and ecclesiastic don't really make much difference in helping us understand how people behaved. But the labels did matter. There are some things that lay people did that clergy did not, some things that lay people could do that clergy could not. The distinction was important to the people who wrote our sources, therefore they should be important to us. Our picture then has edges. At one end of the picture, we see lay people dealing only with each other and with their own concerns and affairs, just as the clergy did on their end. The value of the formula collections is that they let me push out into the lay end of the spectrum, even as my feet remain firmly anchored in a world in which the lives of the laity and clergy were intertwined and which we already know a great deal about. What I think Michael is doing in his North Italian context is taking a landscape of sources that is almost a mirror image of mine in that it highlights secular judicial institutions. He's taking what meager but nevertheless real threads that he can find, and he's pushing as far out into the clerical end of the spectrum as he can. The value is in showing us that it was there and in giving us an idea of what it looked like. And not coincidentally, he's also doing much as we did with the Lay Documentary Project. He's showing that something which was thought to have been a development of the 11th and 12th centuries, in Michael's case, a church judicial system that relied on canon law, did not come out of nowhere, but rather had deep roots in the early Middle Ages. Thank you.